Islam Hotep. Shalom Mishkael. Peace to the gods, peace to the goddesses. Peace be upon you, my sons. Peace be upon you, my daughters. Wisdom, strength, and beauty. I know my rights. I reserve all my rights without recourse. All right. Been a very busy past 48 hours. I haven't gotten any sleep whatsoever, but managed to put together a few things we're going to file on Monday. The first, and I'm going to read these as much as I'm able to. The first thing I was able to put together was a counterclaim. Okay. Counterclaim for trespass. Alright. And then we put together a notice of invalid ruling. And I'll read that. Just a moment. And alright, so let's see. I'll read the notice of invalid ruling first. Let's see. To the Sheriff of Los Angeles County, I put the people who are a party to this action, including those people who claim to be the judge and everything on Monday in the case. I put their names right there. Number one. Then I said number two, the minute order issued by the Superior Court of California, County of Los Angeles Civil Division, see accompanying Exhibit C. And then I put Exhibit C over here. And put the minute order in there behind it. I said Exhibit C is not a valid order for the following reasons. Said court is not a competent authority. Said minute order is not a regular order on its face. Okay. Said court is not a competent authority. Number three, California Code of Civil Procedure, Section 262.1, acknowledges that if any order is issued by competent authority, then a sheriff or other ministerial officer is justified in the execution of the order. However, a sheriff or other ministerial officer who knowingly executes an order not issued by competent authority may be subject to personal liability for such unauthorized execution. Number four, said court is not a competent authority in this case because it is not a court of record as required by the 1879 California Constitution. It fails on 2 points. It is not proceeding according to the common law. A. B. The tribunal is not independent of the magistrate who is conducting the proceedings. In this case, the magistrate is acting as the tribunal. Number five, further, the counterplaintiffs have objected to the jurisdiction of the court not of record. Thus, they have not agreed to allow any alternative Nisi Prius court to proceed. Said minute order is not a regular order on its face. Number six, California Code of Civil Procedure, Section 262.1 acknowledges that if an order is valid on its face, then a sheriff or other ministerial officer is justified in the execution of the order. However, a sheriff or other ministerial officer who knowingly executes an order that he knows is not valid and therefore not valid on its face may be subject to personal liability for such unauthorized execution. Number 7, this notice gives rise to the fact that said minute order, though it may have at one time been valid on its face, is not valid, it having been impeached by virtue that it is issued out of a court not of competent jurisdiction. Number 8, further, the minute order is not a genuine order of the court, and it is not considered a part of the record of the court, but merely a part of the clerk's minutes. Conclusion. Number 9, because the minute order is not created by the independent tribunal, but is created by the magistrate, it cannot be a valid order from a court of record. Because the counterplaintiffs, and I put our names, have objected to and have not agreed to a nisi prius court, the said court has exceeded its jurisdiction in issuing such an order. Further, the complainants, and I put our names, is one of the people of California. The state of California is instructed by the legislature via Government Code Section 100, which states, A, the sovereignty of the state resides in the people thereof, and all writs and possessions shall issue in their name. An attack the people upon the sovereignty of the state could constitute an act of high treason against the people. Number 12. Section 11-120 and Section 549-50 each states, the people of this state do not yield their sovereignty to the agencies which serve them. The people of this state do not yield their sovereignty to the agencies which serve them. Nowhere in the record is there any showing that the counterclaimants, a people of California, and I put our names right there, have voluntarily yielded their sovereignty, has voluntarily yielded their sovereignty to the California government agencies. In fact, there has been no response to the affirmative defenses raised in the answer. See the attached counterclaim and exhibits. Further, they are not in default of any contract with the counter-defendant, and they are not a surety for any fictional limited liability entity. Therefore, anyone executing said minute order may be exceeding jurisdiction and may be subject to personal liability for any consequential injury, including the injury of involuntary deprivation of natural rights and of status as a people of this state. And I signed in red and put my fingerprint. So I think now I've never done one of these before. All right, so that's the theory. Now here comes the actual practical part, going and doing battle. So I think that I'm supposed to. Well, here's what I'm going to do. Whether it's my first time or not, I'm going to serve a copy to the other party, and I'm going to use a process server to do that, to make sure they get it. And then I'm going to take the proof of service and file that with the clerk with the notice. Put it on the record and serve a copy to whoever this pro tem judge is that made the order. And then we'll do a motion to vacate that order. I'm going to work on it here after I get some rest. All right, so here's the counterclaim. I'm going to read it. All right, put the heading on there. And then I put first cause of action, trespass. All all right, because they have trespassed on the case by acting under color of law. All right, so they're trespassing on my property, my jurisdiction, my sovereignty, my nobility, my rights, the law. All right, so can't let people, sit there and build their army inside the municipal buildings, and then, every law that's beneficial to you and to us, they either hide or block you from getting to, or some crazy mess, evil mess. First cause of action, trespass. Parties, number one. Counter plaintiffs, and put our name, is one of the people of California, and in this court of record complains of each of the following. And then I put the respondents, each, here, and after, and all collectively, who are each summoned to answer the said counter-complainant in a plea of trespass on the case, and malicious prosecution, to wit. Introduction. Each counter defendant exceeded his jurisdiction by either directly, through an agent, or in concert with another, did cause counterclaimants to be unlawfully and forcibly removed from premises against their will, without jurisdiction or good cause. I may have to fix that. I meant to. I don't want to assume, because what all they've done actually is got a summary judgment, so I'm going to have to retype that. At the onset of the malicious prosecution, counter plaintiffs were duly in good faith in a negotiation and a written contract agreement whereby the counter defendants did perform the first 8 weeks and afterwards did breach the contract and have refused to abide by the terms and conditions of the arbitration clause in the written agreement, and instead have unlawfully and falsely hired such and such to file an unlawful detainer, Exhibit D, unlawful detainer, case number such and such, for breach of an oral contract and demanding possession of the premises, the cancellation of the rental agreement, as well as forfeiture of lease agreement. The counter defendants have entered a minute order into the court without notice to the counter plaintiffs, without trial or due process. The counter defendants have all acted under color of law to deprive the counter plaintiffs of due process. Although counter plaintiffs objected to the assumed jurisdiction oral contract, as the statute of frauds requires a written contract to which the counter defendants did not respond or answer to counter plaintiffs, and requests for proof of jurisdiction or answers to the affirmative defenses. Counterclaimants are now being forced to be subject under color of law to the assumed jurisdiction, will, and control of the counter defendants. Under color of law, counter plaintiffs have been subjected to a minute order giving possession to the counter defendants without any trial or without the opportunity for counterclaimant to object. Counter defendants refuse to abide by the written contract, which stipulate that only arbitration would have jurisdiction in this matter. Specifics. Number 5. Each counter defendant acted in such a way or failed to act in such a way that counter claimant are deprived of their rights, property, and liberty. Each counter defendant acted to deprive counter plaintiffs of their rights, property, and liberty. Or each counter defendant failed to act to prevent the loss of counter claimant's rights, property, and liberty. Further, each counter defendant is a willing participant in concert with each of the remaining counter defendants. At all times mentioned in this action, each counter defendant is the agent of the other. And in doing the acts alleged in this action, each is acting within the course and scope of said agency. The following paragraphs describe what the counter defendants under color of law either acted or failed to act as obligated. Each counter defendant exceeded his jurisdiction under color of law. Each counter defendant acted in concert with the remaining counter defendants to effect the unlawful loss of rights, property, and liberty of counterclaimants. Number 8, on or about January 9th, 2019, counter defendants offered lodging to counter claimants. On or about May 9th, counter claimants offered tender of payment, conditional acceptance under notary protest to which the counter defendants did default and failed to respond to the offer. The offer clearly stipulated that silence would be considered acceptance. The offer also contained an arbitration clause that prohibits the counterclaimants from filing any claim outside of the jurisdiction of the arbitration clause. The offer contained a private money order. The private money order covered over 1 year of rent. A private money order requires special private banking procedures. No actual transfer or possession would take place until the counter defendants answered the letter under penalty of perjury, or remained silent as acceptance. The offer clearly stipulated that silence would be considered acceptance, and the arbitration is binding on all parties. Failure to follow the terms and conditions of the offer weighs on the stoppers any future complaints raised by the counter defendants in this manner. Number 9, counter defendants performed for the first 8 weeks. No requests for rent were made by the counter defendants. After speaking with counterclaimants and acknowledging the breach of contract, on or about July 2nd, counterclaimants made a complaint to counter defendants that the hot water had been shut off. The counter defendants called the police on the counter plaintiffs for making the complaint and requesting a new room with running hot water for the remainder of the stay. The police admitted that this was a civil matter and to get a court order to be moved to another room. And the hot water was cut back on as soon as the police left. Number 12, the California 1879 Constitution defines all California courts to be courts of record. On or about August 13, 2009, counterclaimant was awfully found liable for breach of oral contract before a court not of record, and also not a nisi prius court. Exhibit D contains true and correct copy of the official record of said court. Whoever this person's name is, acted as a tribunal and magistrate. This person acted as a judicial assistant. This person acted as a bailiff. This person acted as prosecuting attorney. Counterclaimants objected to the jurisdiction of the court and answered with affirmative defenses, along with the request for discovery, demanding the counterfendant to be honest about the written agreement that he is in breach of the agreement and obliged to arbitration, specifically by the association herein, only as dispute resolution. Counter defendants, altogether, without proof of jurisdiction, have ignored counterclaimants' objections and proceeded under code of law to continue the deprivation of the rights, property, and liberty. At no time have counterclaimants waived any rights. At no time did counterclaimants receive any notice of hearing regarding the motion for summary judgment that was held August 13, 2019, 8:30 a.m. This one is, let's see how many more pages. This one is kind of long. Let's see. Number 13, on or about counterclaimant unknowingly and without notice had a summary judgment ruled against them before a court not of record and not an nisi prius court. Exhibit D contains a true and correct copy of the official record of the said court. These such and such people acted. Counterclaimants objected to the jurisdiction. Once again, the malicious prosecution, they have acted dishonorably, have trampled the dignity of the court by deliberate negligence for procedure. Because of the actions committed with actual and implied fraud or the lack of performance of the counter defendants, counterclaimants were immediately and directly injured and suffered loss of liberty, malicious prosecution under color of law. Counter defendants have a duty to not cause counterclaimants to be deprived of life, liberty, or property without due process of law, nor deny to any the counterclaimants within its jurisdiction the equal protection of the laws. Further, counter defendants have a duty to provide all material facts. Counter defendants have a duty to come before the court with clean hands when seeking remedy. Counter defendants have a duty to prove jurisdiction when objection to jurisdiction is asserted. Counter defendants have a duty to answer to the affirmative defenses raised by the counter claimants. And counter defendants have a duty to provide discovery when requested. Counter defendants have breached that duty. Number 25. Number 26. The damages for the injury caused by counter defendants' actions are to be determined by the arbitration hearing. such and such and such. Number 27, the damages for the injury caused by counter defendants' absence of required action is a minimum $5,000 for each failure to act and totally determined at the arbitration hearing. Second cause of action, trespass on the case. Number 28, paragraph 1 through 27 of first cause of action are included by reference as though fully stated herein. By right, counterclaimant reasonably expects to proceed without injury, secure in their capacities. By right, counterclaimant reasonably expects to exercise their right to negotiate and to enter a contract. Number 30, counter defendants have a legal duty to use due care and not cause an injury to plaintiff or interfere with said rights in any way. Number 31, counter defendants breach that duty by approximately or legally, directly, and indirectly causing injuries to plaintiff. Number 32, the damages claimed are all a result of the injuries. Third cause of action, trespass on the case. Number 33, paragraphs 1 through 27 of first cause of action are included by reference as though fully stated herein. 34, power is never without responsibility, and when authority derives in part from government's thumb on the scales, the exercise of that power or private persons becomes closely akin in some respects to its existence by government itself. The purpose of imposing vicarious liability is to ensure the cost of injuries resulting from defective actions are placed on the source of the actions and others who make the actions possible rather than the injured persons who are powerless to protect themselves. For a counter defendant to be vicariously liable, it must play an integral and vital part in the overall production and promotion activity so that the actor is in a position to affect others, or at the very least, it must provide a link in the chain of exposing the ultimate victim to the actor. The vicariously liable counter defendants must be in the business of controlling, leasing, bailing, or licensing the actors. Number 36, each counter defendant is an agent of the other, and each has his place in the chain of exposing counter plaintiffs to the actors. Each counter defendant is vicariously liable for each instance of injury to counter plaintiffs. Law of the case, Exhibit G, is incorporated by reference as though fully stated herein. Request for relief. For that cause of action, therefore, plaintiff brings their suit. Number 38. Number 39. Wherefore, counterclaimant requests relief and judgment against counter defendants as follows. Number 40. Wherefore, plaintiff prays judgment against defendants and each of them as follows on all causes of action. All right. Then I put general damages to be determined at the arbitration hearing, pursuant to the written agreement. Number 42, for extreme emotional distress. Number 43, that the court entered the declaratory judgment. The counter defendants have acted arbitrarily and capriciously, have abused their discretion, and have acted not in accordance with law, but under color of law. Number 44, that the court make a declaratory judgment that counter defendants have acted contrary to constitutional right, power, or privilege. Number 45, that the court enter a declaratory judgment that the counter defendants' actions were in excess of statutory jurisdiction, authority, and short of statutory right.